Good afternoon. This is Hannah Cockburn. I'm the Vice President for Professional Development with the North Carolina chapter of APA. If you can all please mute your phones so we don't get any unnecessary noise on the line, that would be appreciated. We're very fortunate today to have Adam Lovelady with us to provide the 2018 legal roundup for planning and zoning law issues here in North Carolina. As many of you know, Adam is an associate professor of public law and government at the UNC School of Government. He's going to be discussing a range of things with us today, including notable legislative changes, new requirements for reporting permitting fees, and summarizing some of our perennial issues like plan consistency statements and sign regulations. If you have questions for Adam throughout the webinar, I'll be monitoring the chat box. Please type in your questions and we'll get those to him to answer. Again, please mute your phone so that we can provide a clean recording of the session. With that, I'm going to turn it over to Adam. Thanks again for joining us. We really appreciate you participating today.
Thanks, Hannah, and thanks everyone for joining. And yes, this is the 2018 Planning Law Roundup, and really was set up. Hannah was instrumental in getting this set up to make sure that planners across the state of North Carolina could get those much-needed legal credits in before the end of the year, and especially since we faced some scheduling challenges with Hurricane Florence showing up at the same time as the planning conference this year. Hannah has been great in organizing and coordinating both the ethics session last week as well as this legal session to make sure that folks are getting the CM credits they need. So Hannah, thank you for helping to pull all this together and make it happen. Random note, as I was sitting here looking at my own slide, I began questioning whether Roundup is one word or two. I looked it up, and when used in the noun form, it can be one word. So I didn't have to do a last-minute edit on that, but fun fact to get us started. I did want to note, many of you are familiar with the resources available from the School of Government. I'll reference several of these as I go through this session today, but I did want to make sure that everyone was aware. We've got a range of publications and resources available, both online and as print resources. The main things that I'll be noting as kind of background and additional resources today are blogs that have been posted to the Coates Canons blog. And both David Owens and I contribute to the Coates Canons blog, as well as other colleagues here at the school. And several of the topics I'm going to be covering are covered in more detail in specific blogs on the Coates Canons blog. Also, David Owens and I put out earlier this fall a summary of this past legislative session and the new laws affecting planning and zoning in North Carolina. So that's another resource that I'll reference as we go through. And if you need some follow-up detail after this webinar, then I would recommend checking out that the legislative summary bulletin, and that's available on the website. I'll have links available featured on the webinar toward the end of the session. Also wanted to make mention of some things that are coming up. Many of you work with local boards, planning boards, boards of adjustment, elected officials making planning and zoning decisions. And as we have in past years, we will be doing another round of the spring board workshops across the state. We'll be coming to 5 or 6 regional locations scattered across the state. Hopefully we'll get somewhere close to you. It's hard to get everywhere to every corner of this big, wide state, but we are trying to make it out to as many regions as we can. So be looking at the start of 2019, look for more details about locations and timing. Typically, it's in April and May that we host those board workshops. This year, those will be focused on quasi-judicial decision making. So if you're working with boards making, if you're working with a board of adjustment, or you're working with planning boards or governing boards making quasi-judicial decisions like special use permit decisions, then that may be a useful workshop for you or your board members, making sure that they're following the right quasi-judicial procedures for this. We've also got, if you're not able to make it to the workshops, or if you are but need some other specific training, we do have the on-demand modules that are available online through our website, as kind of similarly focused on planning boards and governing boards making zoning decisions, and kind of guiding them through those different types of decisions, but looking at broader topics, things like vested rights, like legislative rezoning process, subdivision approvals, exactions, and the like. All right, a good time to give a reminder of, be sure to mute your phone once you join the webinar. Otherwise, it will create noise for the rest of us, and we might hear your side conversations, which you may or may not want us to hear. All right, so now for the content for the afternoon. This is a roundup. It's a kind of smorgasbord of different legal planning topics that have kind of bubbled up over the last year. I have tried to organize them in some semblance of organization, and this is the best I could do of creating some buckets of topics that I'm going to be covering. First off, some planning and recovery topics, both thinking about recovering from storm damage and the recovery that many of our communities are facing now in the wake not only of Hurricane Matthew, but now Hurricane Florence, and some of the planning and zoning topics that have come up around that. But then also looking at the opioid crisis and the ways that North Carolina communities are addressing and trying to mitigate and address the opioid crisis that's coming, or it is, across our state, and a specific way that's been bubbling up in the zoning world with regard to syringe exchange programs. So I'll speak to that briefly. I'll also do a quick summary of the legislative changes that have come up in this last session in 2018, covering things like some changes to the building inspections requirements and who can do building inspections, changes to the reporting of inspection fees, and some related legislative changes, as well as a little primer of some other topics that may be coming up in the future legislative session. Finally, I'll spend a little bit of time on some perennial zoning issues, things like sign regulations, like consistency statements, which my colleague David Owens just put out a report on the practice and law of plan consistency statements. So I'm going to speak for a bit on that. And if time allows, I'll highlight a couple of cases on bona fide farms and those yet another perennial zoning issue for us here in North Carolina. So that's the roadmap. That's what I'm planning to cover. It's a lot and a lot of different topics. Hopefully it's a little bit of something for everybody, and hopefully not too much of everything to bore everyone out of their minds. But I'll try to keep it moving and keep it engaging so we can, everybody can get something out of it. If you will, please do add in your questions through the chat box as we go. You can type those right in, and then Hannah is kind enough to kind of moderate and add those questions in either at stopping spots or as they need to be addressed as we're moving forward. All right, with that, here we go. So thinking about planning and recovery, first thinking about storm recovery. Of course, we've all seen the pictures, and many of you are living the experience of communities or families recovering from the flooding that we've seen across the state. And one of the ways that this is kind of has affected and has tripped into the planning and zoning world is with regard to temporary housing, as FEMA is and is continuing to deploy temporary housing into communities, and questions about how does the local zoning interact with this temporary housing? How do we address something of this temporary nature and this necessity within our zoning ordinance? This, of course, it comes up in a variety of ways, but the main types of housing that FEMA has been deploying, they have been deploying recreational vehicles, RVs, for shorter term recovery plans, for 6 to 12-month recovery recovery plans if the house is not overly damaged, and so they think the recovery can be within a short time frame. For longer term recovery, FEMA is using manufactured homes and deploying manufactured homes for recovery time periods that might be up to 18 months. And of course, RVs and manufactured homes are things that are addressed by many zoning ordinances, and there are specific limitations and regulations with regard to where RVs can be parked and lived in, where manufactured homes can be located, and what requirements may come along with those. So as communities began the recovery and they began working with FEMA trying to facilitate the recovery process, one of the questions that came up for many communities was, well, how do we adjust our zoning ordinances? How do we make sure that we're finding that balance between allowing for the necessary recovery, but also preserving our interest in public health and safety, our interest in community appearance, and making sure that we're not creating more problems than are already there. As communities have been addressing this, these are some of the topics that have come up, and some of the topics that zoning amendments have needed to address in order to make sure that the local zoning ordinance is allowing for the FEMA trailers to be deployed and to be installed in a both safe and quick manner. One of the issues is just, as I mentioned, considerations of what housing types are going to be deployed. Are they RV trailers? Are they manufactured homes? And are those different housing types treated differently under the ordinance? Are they treated differently as temporary housing? Separate issue is questions of location. Where are the temporary housing options going to be allowed? Are they only on the lot where a house is currently being repaired? Or are there, is it a broader allowance for temporary housing to be allowed across the city or in specific districts of the city? In some cases, there are needs for, because the recovery needs are so great, there can be situations where there needs to be essentially FEMA trailer parks set up in a commercial parking lot, at a campground or some other public space in order to have the space and provide that housing that's needed. Time frame is an important consideration for this temporary housing. Many ordinances were either already set up or were amended to allow for temporary housing on a very temporary basis, maybe 30 days, maybe 60 days, maybe 90 days. But in actuality, the FEMA's expectation is that this temporary housing will be for up to 18 months. And when you think about the extent of the damage and the needs of the recovery, it's the notion that this temporary housing need would be gone after 30 or 60 days just isn't practical. And so thinking about the time frame for these temporary housing options is a related piece. The dimensional and design standards, many ordinances address manufactured homes, and the statutes clearly authorize having dimensional and design standards for manufactured homes. And those are, in many communities, important aspects of the standards, but they also add cost, they add time for installation, and they add a level of oversight and some questions for some communities as to whether what are the appropriate level of dimensional and design standards if these are going to be temporary housing options, not permanent. One of the real challenges for deploying these homes is that they're going into lots of different, onto many different lots, many different situations with many different dimensional standards applying to them. And so one of the considerations for temporary housing is it appropriate to have some level of administrative modification? Is it appropriate to allow for the inspectors or the planning official to have some leeway to make some adjustments on setbacks, to make some adjustments on height limits or proximity to property lines in order to accommodate these unique and temporary situations? Then there's also the essential questions of public health and safety, of making sure that these temporary homes do have safe and appropriate connections to the utilities, and that they're not put into harm's way, that we're not putting folks right back into a flood hazard, and putting them right back into a situation where they may be evacuating again in another 6 months or 6 weeks or 6 days. And then, of course, there's questions of permitting and administration. How do we handle this process? How do we as a community facilitate the quick deployment of temporary housing, but also make sure that standards are met, make sure that that construction is appropriate and safe as the temporary housing is deployed. So those are some of the considerations. Of course, many of you have experience with this, and you're probably already thinking of other considerations. And for each community, it's a different set of priorities, but these are some of the things that communities, as they're adjusting standards, as they're adjusting ordinances to allow for temporary housing, some of the topics that have come up. One of the procedural questions that came up as communities were trying to allow for quick deployment of temporary housing was, well, how do we quickly amend an ordinance? How do we act quickly so that we can have the rules in place and allow for folks to get a FEMA trailer, allow for them to bring their own RV onto their property and live in their own RV while they're managing their home? And of course, the zoning amendment process is deliberately structured to be slow and deliberate. It has additional notice requirements. It has a requirement for a public hearing, requirement that the zoning amendment be sent to the planning board for comment, and that there be 30 days at least for the planning board to give comment. And so in most circumstances, the planning and zoning rules recognize a need for slow and deliberate decision-making around planning and zoning topics. But in this situation, there's a need for quickly changing the ordinances and allowing for that temporary housing to be deployed and for folks to have the safe homes that they need. And so one of the questions that came up was, well, how can we speed up this process? There is, while an ordinance amendment, a change to a zoning ordinance does have to follow the statutory requirements for zoning amendments, it is possible to speed up that process to an extent. And one of the things that that I have outlined in the blog on this topic that I'll note in just a moment is a way for a community to structure the amendment process in order to most quickly get something approved. And some of the things that you have to pay attention to if you're going to be quickly amending an ordinance, whatever the meeting is, you want to make sure that you follow the rules for the appropriate general notice of that public meeting, whether it's going to be a regular meeting, a specially called meeting, or emergency meeting. And so you got to follow the basic rules for that meeting notice. You do also have to follow the notice for zoning amendments, and so that's the the newspaper published notice in that window of time between 10 days and 25 days before the meeting, and then another published notice in a separate calendar week. And there is, you can, if you're thoughtful about the calendar and about when that publication goes out, you can do it relatively quickly with regard to that upcoming meeting. The biggest way of speeding up the process is allowing for the planning board and the governing board to hold a joint meeting. This is clearly allowed, and the requirement for the planning board to give comment, it does not require that be at a separate meeting. It doesn't require that it be in advance or significantly in advance. The requirement for the planning board is merely that they give their written comment to the governing board in advance of the governing board making their decision. And so it's perfectly appropriate and possible to hold a joint public hearing where the planning board and the governing board would hold the public hearing, would hear the comments from the community, and then the planning board can deliberate and adopt their, make their decision and give their written comment. And then it would turn to the governing board for them to deliberate, to adopt their consistency statement, and make their decision on the case. And as I noted in the blog on this topic, I walked through kind of the timeline for that, and even some sample board statements and consistency statements that could be used as a kind of guide for that to quicken that process. Separate from the effort to change the local rules to allow for recovery, there was also a change that was made by the General Assembly in Raleigh about what fees can be charged related to the recovery. The Hurricane Florence Disaster Recovery Act, which was Senate Bill 3, was passed this fall in the wake of Hurricane Florence. And among other things, it established a moratorium on charging fees that are associated with permits or inspections for commercial and residential projects. This applies specifically to those counties that were declared disaster areas. So if your community is in one of those places, then there is a moratorium on charging those permit fees. It was, as it's adopted, it applies retroactive to September 13th, so back to the storm, and it continues through December 31st this year. And there is a requirement in the law that the local government post a notice of availability of refunds. So if a local inspections department continued charging, well, most all of those departments were still charging for the basic permit, even in the wake of the storm, applicants would have a right to a refund for anything that was charged after the storm. And then also, if there's been anything that's been charged since then, those would also be available for refunds through December 31st. But once we get to 2019, then those local inspection departments can start charging those fees for permit inspections and certificates of occupancy once again. I mentioned a moment ago my blog on this topic, and so with regard to the zoning amendments, I have kind of outlined some of the considerations and the procedural considerations there. My colleague Norma Houston has also written a blog with regard to that fee moratorium and the applicability of that fee moratorium. You can find both of those on the Coach Cannon's local government law blog. So from hurricane recovery to substance use recovery, I want to switch gears to talking about syringe exchange programs and how those might interact and relate to the local zoning ordinance. First, I think it's important and helpful to get a sense of the extent of this crisis. In 2016, the state had nearly 5 North Carolinians a day that passed away from unintentional medication or drug overdose. 5 of our neighbors, 5 of our fellow citizens, 5 North Carolinians dying each day from overdose, many related to opioid use and misuse. And we're seeing significant changes in the way that this is playing out and the types of drugs that are affecting our neighbors and fellow North Carolinians. While there was significant increase in the use of prescribed opioids, that really has plateaued off in recent years. But you can see here the spike in recent years of a combination of prescribed and illicit opioids, but then here the green, the significant increase in overdose deaths related to heroin and other synthetic narcotics, things like fentanyl and carfentanil, that have really driven the spike in overdose deaths in recent years. And the impacts go far beyond just the overdose deaths. So this pyramid really kind of gives a sense of the broader scope of impact for our communities beyond just the deaths. And certainly the deaths are tragic, the deaths are preventable, and the deaths are important, but it goes far beyond that. And so for each death, there's almost 2 hospitalizations that are occurring. There are, across our communities, about 3 emergency department visits for each of those deaths. And then spreading it out even further, 260 incidences of misuse of prescription medications, and over 5,000 pills prescribed related to opioid misuse. With all of that as backdrop, our local communities are taking lots of steps to address the impacts and the harms created by this crisis. You all have, I'm sure, seen this in your community, and you may well be involved in the wide array of ways that local governments and communities are responding and trying to find solutions to this challenge. I've been fortunate to be working with a group here at the School of Government, as well as a group of communities across the state, trying to find new ways to collaborate and work across departments and across organizations to find ways of responding to this opioid crisis and get both individuals and communities the recovery that they need. One of the topics and one of the tools that local governments and communities are using are syringe exchange programs. Syringe exchange programs are operations and programs that are providing sterile needles and syringes and injection supplies, as well as providing safe disposal of needles and syringes. And this is a public health effort that's really focused on reducing the negative consequences of injected drug use, both for that individual as well as for the broader public health considerations. Now, syringe exchange programs were made legal in North Carolina in 2016, and there are requirements in order to be a lawful syringe exchange program in North Carolina. It's required that you have your organization is providing a range of things, and the 2016 law required these things to be provided: sterile injection supplies, and those have to be provided free and in sufficient quantities so that they're not that a user is not sharing needles nor reusing needles. A syringe exchange program has to provide for safe syringe disposal, so a Sharps container or Sharps disposal container, and taking care of those disposed syringes and needles. The syringe exchange program has to provide security for the site, for the personnel and equipment. They also have to coordinate with local law enforcement to identify their security plan and make sure that that local law enforcement is aware of their operations and how they're coordinating that. Each syringe exchange program has to provide information about the prevention of disease transmission, of overdose and substance use disorder, as well as referrals for treatment options, and referrals for mental health and substance use disorder treatment. Another thing that North Carolina syringe exchange programs have to provide is naloxone, and that is the overdose reversal drug that is used to revive folks who have overdosed. And so the syringe exchange programs have to provide either naloxone or referrals to where individuals can get naloxone. Syringe exchange programs operate in several different ways. Some of them are established as fixed site or integrated syringe exchange programs, where they are at a certain physical location. Maybe it's at the public health office, maybe it's at a fire station, maybe it's in relation to a soup kitchen, maybe it's in related to a recovery clinic, maybe it's in relation to a church. But they can be at an established, identified location, and oftentimes those are integrated within a larger operation or organization. I'm not aware of any that are merely standalone fixed site syringe exchange programs. They are almost always related with some other organization or some other use on the site. These programs can also be set up as mobile syringe exchange programs, so operated out of a van, out of a car, to meet individuals where they are, and they can even respond to calls or texts, and so going out to do syringe exchange at the place where the individual is needed. They can also be set up as peer-based models, where recovering individuals are providing for both the clean syringes, the new syringes, as well as the safe disposal of syringes, and connecting individuals with the recovery they may need. So all of that is background to, well, how does this relate to planning and zoning? How does this trip into the world of the local planning office or local inspections office? One of the things that has come up I'm aware of it in a couple of communities, I'm sure it's happened in others, is new syringe exchange programs have opened and authorized under the new state law. But there have been questions from neighbors as to, well, is this a lawful use? Is this something that's allowed under our zoning ordinance? Is this really allowed in my neighborhood? And really it becomes kind of a classic zoning dispute where neighbors question, is this change appropriate for this location? Do our rules allow for this type of use in this place? And because it does wind up being something of a conventional zoning dispute, just with a different use, it really turns on the same kind of conventional questions of zoning and land use. The answers as to where are syringe exchange programs allowed and how do they relate to the zoning ordinance, they're going to depend on the nature of that use, the nature of the syringe exchange program, as well as the details of the ordinance. And really, this is kind of just traditional zoning interpretation and zoning enforcement. In many cases, the syringe exchange is really operating as an accessory use. It's attached to some sort of principal use on the site, and it is not the principal use that's there. And so in many cases, they can be treated as accessory uses. Indeed, for many of the existing syringe exchange programs, they are operating for some short window of time during the week. Maybe it's Tuesday and Thursday afternoons, or maybe it's Friday mornings and Saturday afternoons. Many of them have kind of established short windows of time when they're operating. They're not even a full-time operation on whatever site that they're sharing. Alternatively, a syringe exchange might be set up and permitted as a temporary use, or it might be set up as a mobile use. And so the questions would be, well, what type of syringe exchange program is this? What's the nature of the operation? And then turning from that to the questions of how does the ordinance handle this? What are the definitions in your ordinance? What are the use categories, and what districts allow for different use categories? And what are the development standards that might apply for a syringe exchange program? Of course, these, like any kind of zoning interpretation question, it's going to be unique and specific to that use and that ordinance. It's impossible to say from a statewide perspective, yes, all syringe exchange programs are allowed here. This really is a question of local land use regulation and local permitting. And so look to the specifics of that syringe exchange program, the specifics of your ordinance to decide if that use is allowed or not. And I did put in similarly, I've got a blog on the Coach Cannon's blog addressing those same considerations and outlining the basics of syringe exchange programs and what's required of them under state law, as well as how they might fit under a local zoning.
Adam, this is Hannah. We had a question in the chat box. If allowed via zoning in a city, who checks that they meet the other rules?
Good question. So I'm presuming that means who checks they meet the state requirements for providing naloxone, providing referrals, providing safe disposal. That is coordinated through the State Department of Health, and they may cooperate with the local health departments, but there is a requirement for registering with the state, and it is the State Department of Public Health that will be confirming that those operations meet their requirements. And so certainly the local planning office will be confirming if there's specific operational limits for that, program, if it's, whether it's allowed or not allowed in that zoning district. Those local zoning questions would be for the local planning office or inspections office to handle. but the state level requirements, the state handles that kind of certification and permitting. And I am just about to transition away from planning and recovery to thinking a little bit about the legislative changes that have come. Any other questions with regard to either syringe exchange programs or the adjustments at the local level for temporary housing in the wake of storm recovery?
Adam, we don't have anything else in the chat box, but I'll continue to monitor.
Sounds good. Thank you. All right, moving right along, legislative summary. So in September, David Owens and I did put out a summary of the changes to planning and zoning laws related to, well, planning and zoning. This year was not a major year for changes to planning and zoning. I'll go through, I'll kind of highlight a few of the changes that came through, but was not a major legislative year. But the bulletin does walk through and kind of outlines those specific changes that came. That legislative bulletin is available on our planning and zoning website, on the School of Government's website. I'll link to that at the end. One of the notable changes that came up was with regard to permitting fees, and specifically a new requirement for local governments to report their permitting fees, what they've collected, to the state. And it's a new requirement, a new reporting requirement, and the specifics of what exactly is meant by it is a little bit unclear, but I think we've got a pretty good guess as to what it means. But in order to understand the kind of confusion and what I think they're trying to accomplish here, we've got to step back and think just about the structure of the local government authority under the general statutes. So this is the basic structure of Article 19 of Chapter 160A of the North Carolina General Statutes. This is where cities get their authority for zoning and subdivision and building inspections, all the kind of development regulations that cities do is authorized under Article 19 of Chapter 160A. If you're with a county, your authority comes from Chapter 153A, and there it's Article 18, but it's very similar. It's essentially the same parts, the same structure. And so with these parts, we've got kind of the general allowance of kind of the general structure. Part 2 is the subdivision regulations. Part 3 is zoning regulations. We get down here to Part 5 is building inspections. And one of the things that gets confusing with regard to city and county authority for regulations is up here for subdivision and up here for zoning, there's not any specific authority with regard to inspections. There's not a there's no zoning officer created up here in Part 3. There's no up here in the general provisions, there's no requirement for planners to oversee site plan review. All of that administrative authority, all the authority for the inspections department, that comes from down here in Part 5 under building inspection. And to be sure, Part 5 is mostly focused on building code inspections, on the building code, the fire code, the plumbing code. That's really the heart of this, is setting that up and requiring local governments to handle it. But this is also where we get zoning inspections and the authority for charging fees for zoning permit applications and the general administrative authority for planning and zoning. It comes from Part 5. So keep that in mind as we kind of talk about the way that this new law is structured and the way that the permitting fee requirements are structured. So one of the things that we find in Part 5 is the authority to charge fees. 160A 414, and then there's a comparable county statute in Chapter 153A. It says that cities and counties shall have power to fix reasonable fees for issuance of permits, inspections, and other services of the inspection department. So plainly, there's authority for charging reasonable fees, fees to cover the cost of processing an application, fees to cover the cost of going out and doing an inspection. The local government has authority to set and charge those reasonable fees. A few years ago, there was a specific limitation or clarification around these fees, and that was the statute was amended to say that all fees collected under the authority set forth in this section shall be used for support of the administration and activities of the inspection department and for no other purpose. Now, to some extent, we already knew this from some court cases and from some basics about setting permitting fees, that, look, the local government should set the fees to recoup some or all of the cost of processing that permit, of doing that inspection, but this can't be a revenue generation scheme. We're not going to use building permit fees to increase our library fund. We're not going to use the an application fee to pay for a kind of our HR department. Rather, we're going to use the fees for permits and inspections to pay for the cost of permits and inspections. It needs to be reasonably related to how much does it cost for us to go out and do this inspection, to have that staff, to pay for that staff time, to pay for the overhead of the building and the computer system and IT to support the building inspections and permitting process. This year, there was an additional change it's kind of related to this topic. Now, it was already the case that each year the finance officer for each local government had to submit to the state, to the local government commission, a statement of financial information, and there was already a requirement for specific topics to be included in that. But really, it concerned the general fiscal health of the local government. But this year, the General Assembly added, among the other specifics that must be reported to the local government commission, it's now required that your local finance officer has to report the total revenues received from building inspections by type and the total expenditures paid from all revenues received by type. And so starting in 2019, the local finance officer for each city and county has to, as part of its reporting to the local government commission, reporting to the state about the fiscal health of the local government, has to report, well, how much money did you receive from building inspections and how did you use that money? And going back a slide, there's already the requirement that these fees be used to pay for permitting and inspections activities. And now there's a requirement, not only do you have to make sure that you're keeping those funds within the inspections department, within the permitting department, but also we want you to report out how much money are you getting in and how are you spending that money. And from the outset, it makes sense. That's a perfectly reasonable thing to consider. You can only use these funds for certain purposes. Let's confirm that local governments are indeed doing that. They're taking in funds, they're using it for permits and inspections. But because of the structure of the local government authority, because of those different parts that I outlined up here, there's a question of, well, does this, when we're reporting in the fees received as well as how those are used, is that merely for building code inspections? Or is that for any and all permits and inspections under Article 19? under the development regulations. It's not perfectly clear because this is where we get building and zoning, this is where we get zoning inspections authority under Part 5. And so we've had to do a little bit of kind of analysis and interpretation to figure out, well, what's meant by this reporting requirement. One piece that helps is this language of reporting those revenues by type and reporting how those expenditures are paid by type. It seems to me that this is likely referring to by type of inspection, such as whether that was building code inspection or electrical code inspection or plumbing code inspection. Also, from the legislative history, the committee this came from and the discussions that this was related to were very much related to building code inspections and very much related to the kind of specifics and the cost associated with getting inspectors out for building code, for plumbing code, for electrical code. So it seems likely that this is talking about building code revenues from building code inspection fees. But it's because of that structure of the statute, it's just a little quirky as to how it actually applies. Now, I've kind of skated across a lot of the details that go into this, but I do have yet another blog. Sorry, this winds up being kind of just me highlighting various blogs from the fall, but I was trying to put out some information that would be helpful. If you have not seen, or if your local finance officer needs some clarification on how this new accounting of permitting fees is, how it's going to apply, there is this blog from September looking at that topic and hopefully providing a little bit of clarity on that topic.
Adam, before we move away from fees, we had a question on the chat box about the fee moratorium. Does the moratorium on fees only apply to properties that were affected by the flooding or to any permits issued during this time period?
Really good question. I know that it's limited to those counties that were declared disaster areas. I think that it is broad for any construction and inspection, or any permits and inspections in that jurisdiction. But I would have to look back specifically at the law. I don't think that it's limited to just recovery properties. I think it is broader. And so but I would have to look back at the specifics of that law to remind myself of that. All right, continuing with the theme of building inspections, there were several changes this year to allow for essentially to increase the number of inspectors and to reduce the requirements for building inspections. And this really is focused on building code inspections. This is not specific to planning and zoning, more to kind of building code, straightaway building code inspections. One of the changes that came this year, there had already been a change in 2015 to allow for architects and engineers to certify that certain designs and installations met the building code standards, so there was not a requirement for an inspection to go along with that. The 2018 law, there was some clarifications provided for how that law is to be applied, making it specific that applies to building components or elements, not to building systems. It allows for that certification coming from the architect or the engineer to be electronic or physical. And then for the city or county that's accepting that, they've got to confirm the receipt of that certification by the same means, either electronic or physical. And as part of that, if the architect or engineer is signing off and sealing, yes, this meets the standards, this new clarification has made clear that the city or county is released from liability related to that non-inspection, because that's the architect or engineer is taking on that responsibility. Additionally, there were changes to allow for more inspectors, more building inspectors within the state. There is an allowance now for local governments to have mutual aid contracts for building inspections. So if one jurisdiction has a spike in construction permits and inspections, then they can have another jurisdiction to kind of share the load, and vice versa. There was already a recognition of some other certifications, so out-of-state certifications. This year, there was a clarification and allowance for comedy for inspectors that are certified by the International Code Council, so allowing for another kind of reciprocity of certification to allow for additional inspectors in the state. There's also, and this is the bigger change, there's now a state pool of building inspectors to try to remedy and address the backlog of inspections in some local governments. Let me give you a little more detail on that, on the specifics of that, and how that's going to play out. It's the Department of Insurance that is establishing the pool of code enforcement officials. And then with that pool established, if I as an applicant if I as a builder show up at the local inspections office and I say, you know, I need to get my building code inspection and I need it now, the local department has 2 days to go out and make that inspection. And if the local department knows, hey, we're not going to make it out there in 2 days, then they can go ahead and tell me. They can say, hey, we won't be there within 2 days. Or if the local department says they'll be there, but then they don't, then I, as a builder, can call on the Department of Insurance and I can request a state inspector from their pool of inspectors to come and do the inspection. Now, with that, the statute lays out a good bit of detail about what information will be provided from the local government to the state inspector, how permits will be handled, and how permit fees will be handled. And the statutes outline some of those kind of technical and procedural details about how this will actually be coordinated. And I presume, although I have not seen, that the Department of Insurance also has more specifics on how this is set up and what kind of information will be shared between the local government inspections department and the Department of Insurance. A couple of things to note of legislation that did not get enacted in 2018, but you may want to keep an eye on for 2019. One is, it was this past session, it was House Bill 507, and that was a collection of requested changes to the zoning authority from the real estate and construction industry. And that was, it included a whole range of zoning changes, both procedural and substantive. And that may well come back in the session in 2019. Also, Senate Bill 419, that was the North Carolina Bar Association's proposed rewrite of the planning and zoning statute, what's been called 160D. That proposal would consolidate the city and county zoning authorities into a new statute, Chapter 160D, and would do a kind of cleanup and modernization of that language, streamlining the statutes, giving some clarification. Some of the challenges, like when I was talking about the permitting fees and reporting the permitting fees, the kind of strange organization that we currently have of the different parts, the 160D proposal would remedy that and give more clarity around administrative authority and who does what. So that's another one to keep an eye on for 2019. A final legislative note before I'll pause for questions and then move into perennial zoning issues. Final legislative note, this was from last year, from the 2017 session, but it is now effective. So I just wanted to highlight that for folks. The statute of limitations on zoning enforcement is now in effect. It took effect on October 1st. And there's two different kind of clocks ticking for this statute of limitations. There's a 5-year clock ticking that starts when the facts constituting the violation are known to the governing body, an agent, or an employee of the unit of government. So if we as a local government have known about this zoning violation for 5 years, then the statute of limitations may have run for us to take that property owner to court over that violation. Similarly, the 5-year clock starts running when the violation can be determined from the public record of the unit of government. And so this is an issue of if the zoning violation is clear from the public record, somebody requested, somebody got a business license for a commercial operation that's clearly not allowed in that district, that would now be in the public record, and that violation could be determined from the public record. There's a separate clock that starts running. A 7-year clock starts running from the time the violation is apparent from a public right-of-way, or when the violation is in plain view from a place to which the public is invited. So that typically that's going to be in a commercial business, the place where customers are invited. So if the gas station, when you walk in to pay for your gas and buy your snacks, you can see the sweepstakes machines, and sweepstakes parlors are not allowed in that district, then that's maybe you couldn't see it from the right of way, but you can see it where the public's invited. So I just saw a question pop up on the chat as to when does this clock actually start running? Does it start October 1st or at the time that that action occurred? October 1st was the effective date of this law, and so after October 1st, you cannot. It would be an affirmative defense for the violator if they got sued. So say, hey, it's been 5 years since the local government has known about this violation. So here's an example. Suppose back in September of 2013, so over 5 years ago, I was operating a salon in my garage, and the city sent out a notice of violation saying, hey, this is a commercial operation. Here we've got evidence of this taking place, and here's your notice of violation. You need to come into compliance within 30 days. Otherwise, we'll bring additional enforcement action. So over 5 years ago, I got a notice of violation, a letter clearly stating that the local government knows about this violation. Now we fast forward to December of 2018, and a new zoning enforcement official is in town, a new city attorney is in town, and they decide they're going to clean up all these old zoning violations, and they try to sue me and take me to court to force me to come into compliance. Well, once we get to court, if I am paying attention, or if my lawyer is paying attention, I'm going to bring out my notice of violation dated from September of 2013, over 5 years ago, and that's going to be evidence that the city knew about this violation over 5 years ago, and I'm going to use that as an affirmative defense against this court case, and the judge is going to throw it out. Now, a couple of clarifications, a couple of important nuances to that. One is that if there's a clear threat to public health and safety, then this statute of limitations will not apply. So if there is, there's dangerous chemicals, if there is, there's the proximity of this use to another use is creating a clear public safety hazard, then the statute of limitations would not apply, and the city or county could still move forward with taking that individual to court to seek compliance. Another nuance, or not really nuance, just clarification, is this is specifically a statute of limitations is a defense against a court case. It's a defense against court action. So if we find out about a zoning, if we as a city find out about a zoning violation, even if we've known about it for 5 years or 7 years or whatever, we could still today send a letter and say, hey, this property owner, this is a zoning violation and you need to come into compliance. We could potentially even charge civil penalties to say, hey, this is a violation and you need to come in compliance, otherwise you're going to rack up these civil penalties. The challenge will come in if and when we as a city or county need to bring a court action to force compliance. We need to go, try to seek recovery of those civil penalties in court, or we need to go get a court order requiring that they come to compliance. If we get to that point, then the violator could raise the statute of limitations as an affirmative defense, and we likely would not be able to prevail against that unless there was a clear public health and safety concern. All right, so transitioning now from legislative summary to some perennial zoning issues with the time we have remaining. And as I'm just scanning back through the questions and comments, on the reporting the revenues and expenses for the inspections department, on my blog, I believe, I'm pretty sure that I did, I linked across to the Department of Revenue or Department of State's, the Local Government Commission, their guidance on the that reporting, that revenue reporting. Let me grab this blog real quick and see if I can double check that. I think that the first period of reporting is going to be July of 2019. I do not think that it is required for the January 2019 reporting. But let me double check. It's not jumping out to me right away, but I believe that it is the first period of reporting will be July of 2019, but you may want to double check with the Local Government Commission on that just to make sure. All right, shifting gears now to some perennial zoning issues. I'm going to first talk about just a kind of quick update or reminder on some sign regulation limits. I want to highlight David Owen's new report on consistency statement and some information from that. And then if time allows, I'll touch on bona fide farm exception. All right, regulating signs. If we're regulating signs, we're regulating speech. And when we're regulating speech, because of the First Amendment of the Bill of Rights, we've got some heightened concerns to make sure that that the government regulations of private speech are not going too far. And when it winds up in court, the court is going to apply a heightened level of scrutiny to those regulations of speech. But to be sure, some regulations can still apply. It's not as if this is just a blank check for any and all signs to go wherever they want. The thing that the courts look at when they're considering sign ordinances, and the things that we as planners and as local governments need to be mindful of as we're crafting sign ordinances and enforcing sign ordinances is, in order to be regulating these signs, there needs to be a substantial governmental interest that's justifying this regulation. And typically what gets pointed to are concerns of traffic safety and pedestrian safety, as well as community aesthetics, protecting the visual character of the community. And those are allowed and justifiable public interests for some sign regulations, not for any and all, but for most of our sign regulations. Traffic safety and community aesthetics are going to be sufficient. But then in addition to the governmental reason for to justify these regulations, there also must be some careful tailoring to make sure that the regulation is actually addressing that governmental interest. It's got to be so that the regulations are not over-inclusive and limiting too much speech, but also that the regulations are not so under-inclusive that they're leaving all these other negative impacts on the purported governmental interest at hand. Now, whenever we start talking about sign ordinances and sign regulations, the details really matter. The type of property is going to affect what regulations might or might not apply. And so is this regulation of signs on government property? Is it regulations of sign on private property? That's going to matter for what regulations might withstand judicial review and what types of rules might apply. It also matters what kind of regulation are we talking about. Is this regulation regulating the content of the sign, what the sign can say or what the sign must say? Is it regulating the characteristics of a sign, things like the height of the sign, whether or not the sign has lights, if it's an electronic sign, how quickly the message is changing? Those types of things are not regulating what the sign says, it's just regulating the physical characteristics of that sign. Then there's also distinctions between, is this regulation regulating commercial messages or non-commercial messages? Non-commercial messages would be things like campaign signs or religious signs or other non-commercial signs that are promoting an idea, not a particular product. As many of you know, the topic of regulating signs has long been a topic for the U.S. Supreme Court and First Amendment jurisprudence, but more recently, in recent years, it has kind of risen again as a topic for concern because of the Reed versus Town of Gilbert case. And in that case, there was the Town of Gilbert, Arizona, had a zoning ordinance that had required zoning permits for all signs, but then it had this whole range of exemptions and exceptions for different types of signs. And it allowed for political signs of a certain size to be allowed without a sign permit, but only during campaign season. But then it allowed for ideological signs that could go up anytime, but those were a different size. But those, again, didn't require a permit. They were exempt from the permitting requirement. And then separately, there was an allowance for what were phrased and defined as temporary directional signs. Those temporary directional signs were allowed 12 hours before an event and 1 hour after an event, but they had to be smaller in size than the political signs or the ideological signs. And the way this case came up was that a local church was posting temporary directional signs because they were at that time without a permanent location, and so they would put up signs to identify where the congregation was meeting in a temporary nature. So they might be meeting at the high school gym for a few months. They might be meeting at a vacant church for a few months, and so they were using temporary directional signs to identify where they were meeting. And they were cited by the local zoning office for not complying with the sign ordinance. And the local church challenged that enforcement, saying that they were being enforced against based on content, that this was a content-based distinction, not this did not concern the character of the signs, rather it concerned the content. that if they had been putting out political signs or ideological signs, they would have been allowed much larger and much longer than their religious signs. This made its way to the U.S. Supreme Court, and the U.S. Supreme Court decided for the church and said, yes, this is content-based regulation, and that kind of content-based regulation has to meet strict scrutiny, the highest of judicial review. And in this case, there's not a justification that the city has given to justify this distinction between different contents of signs. There were some clear lessons from the Reed decision, but there was also some question marks that we were left with after the Reed decision. Over the last few years, there have been several lower court decisions in the federal district courts and federal circuit courts that are starting to give us some clarity around what the Reed decision really means and how it's going to apply for local communities and in the federal courts. Some of the things that we know, content neutral regulations, regulating the size of a sign, regulating the height of a sign, the materials or the location of a sign, those kinds of content neutral regulations are generally okay. But regulating the content of signs, so distinguishing between a campaign sign or another non-commercial sign, that's generally not going to be okay. Now, I'll note in a minute the kind of specifics here on distinguishing non-commercial. That winds up being its own kind of category and specifics. The courts have allowed for, and it appears continue to allow for, distinguishing commercial signs as a different category. And to be sure, that is a content-based regulation. We're saying commercial signs, kind of distinguishing them separately from non-commercial. That's a content-based distinction, but because of the way that courts have traditionally treated commercial speech, they are generally okay with treating commercial signage separately from non-commercial signage. All right, so let me walk through a few of the lessons we've learned, and a few of the ways this is playing out. So content neutral signs, regulations are generally okay. The types of regulations that might include regulating, as I mentioned, the size of signs, the materials of signs, and limiting certain materials, requiring certain materials may be justifiable regulation. Certainly the location of signs, and that would be both the location on a lot, so having a certain setback from the right-of-way, requiring that they be on the building or not on the building, those would be allowable. Similarly, having locational requirements for different districts. So residential districts have a certain set of sign regulations, and commercial districts have a different set of sign regulations. It would be an allowable content neutral regulation. Regulating the lighting, the extent to which a sign is illuminated, the brightness of that illumination, those are allowable content neutral regulations, as well as limiting electronic messages, how frequently it can change, how bright it is, how much it's moving. Those are can be justified based on traffic safety and visual impact. Portability, whether or not the sign is on public property, the number of signs, all of those are valid content neutral regulations that generally are going to withstand judicial scrutiny. An example of how this came up in the village of Downers Grove, I believe this was in Illinois or Indiana, there's a local sign ordinance that restricted painted wall signs. It also restricted the location of signs and the number of signs. In the wake of the Reed decision, this local business challenged that local ordinance, saying that these regulations were content-based and couldn't withstand judicial scrutiny because of the Reed decision. In that case, the federal district court said, no, bans on wall signs are content neutral. It's not saying what the content of that wall sign must be or can't be. Rather, it's a location of a sign and a material of a sign. This is valid content-neutral regulation, limiting wall signs. Moreover, the court found there was not specific evidence that this prohibition, this rule, was set up because of disagreement with those wall signs. Now, content-neutral regulations are okay. Content-based regulations generally are not okay. Only in very limited circumstances would they be allowed. And this came up in a case that arose here in the Fourth Circuit. North Carolina is part of the Fourth Federal Circuit. In this case, it came up in the city of Norfolk, Virginia. They had a sign ordinance that had exemptions for flags of any state, any nation, state, or city, or any religious organization. It also had an exemption for any work of art that didn't identify or specifically relate to a product or service. And there's a business, the Central Radio Company in Norfolk, that had a location that was threatened to be taken by eminent domain, and they were opposing that the threat of being of eminent domain. It was a political message opposing this local action by the government. And so they posted on their wall this banner that was identifying how long they had been in the city and on the location and how many workers they had, and noting that they were threatened by eminent domain, calling for their perceived abuse of eminent domain to be stopped. The city issued a notice of violation against this as an unpermitted sign, and the company challenged that under the Reed decision. In this case, the court found that that it was a content-based restriction and that the city failed to meet strict scrutiny. The governmental interests were not high enough, were not compelling in order to justify this content-based regulation. The city claimed that it was promoting the city's physical appearance and reducing distractions, obstructions, and hazards to pedestrians and auto traffic. While those may be good governmental interests, they may be substantial governmental interests, in order to justify a content-based restriction, they had to be even more than that. They had to be compelling, and these governmental interests were not compelling. Moreover, and this really, I think, was the key here, the tailoring of this regulation was hopelessly under-inclusive, the court said. Here, they were disallowing this banner that was a political message against eminent domain, but they were allowing for art and flags and other visual clutter and so they weren't addressing the broader visual clutter. And the court noted that the flag of a private or secular organization was no greater an eyesore than the flag of a government or religion, and there was no evidence to support that this banner or banners similar to this political banner was any threat to public safety. And so, as we're considering how how courts are going to treat local regulations, how we might need to adjust zoning ordinances, we need to be clear that if we're going to, that certainly local governments can regulate with content-neutral regulations, but if we're going to allow for signs, we need to allow for a range of content. And so here, examples of 4 different examples of non-commercial speech. One is kind of traditional political speech, but the others are related non-commercial speech and should be allowed just the same as the traditional political speech or campaign speech. And if we convert that over to thinking about flags, many ordinances have specific limitations on flags to say they can only be flags of a nation, state, or city, or a religious organization. Many ordinances have something similar to what the city of Norfolk had. But fact of the matter is, if you're going to allow for, if your ordinance is going to allow for state or national flags, they must also allow for other non-commercial flags and the full range of content. So it may even be content that is unpalatable to some citizens or to some elected officials. But if we're going to allow for some non-commercial speech, we need to allow for the broad range of non-commercial speech. Now, separately, it is still allowable that to have distinctions of commercial signs and treat those differently from non-commercial. Even the courts that have kind of taken Reed and made a strong statement with Reed, even the courts that have been skeptical and kind of read Reed in a strong way, they have still enforced a distinction between commercial and non-commercial speech. See here a couple of quotes from some of those cases. The government may impose stricter regulations on commercial speech than on non-commercial speech. We have acknowledged that Reed's holding seems to affect only restrictions on non-commercial speech. And so one of the questions that came out of the Reed decision was, well, does this make a difference for regulations of commercial speech? The answer seems to be no. The Reed decision really is applicable to non-commercial speech, political, campaign, religious, and other non-commercial speech. And one thing that goes hand in hand with that, and an important piece to keep in mind there, is that if you're going to distinguish between commercial and non-commercial speech, if an ordinance is going to treat those separately, they need to make sure, the ordinance needs to be sure to allow for non-commercial on equal footing or better than commercial. So if we're going to allow for McDonald's to put up a commercial billboard, then McDonald's should also be able to put a political or other non-commercial message on that billboard. And one way to do that is to have a substitution clause to make sure that non-commercial messages can be displayed on any sign where a commercial message could be displayed. So if there could be an advertisement for a product, if there could be an advertisement for a service, then there also should be able to be a message related to politics, related to campaigns, related to religion, or some other non-commercial message. In one particular case, just that, a substitution clause managed to save an ordinance because there was a challenge to essentially a content-based regulation, but because the substitution clause was there, that allowed for the non-commercial speech to be on equal footing with the commercial speech. One particular sign topic that I wrote on recently was with regard to temporary signs in the right-of-way. Just make a quick note on that, and then that blog is available if you need additional detail on that. There are rules for signs in NCDOT rights-of-way, so those rights-of-way owned and maintained by the North Carolina Department of Transportation. The state rules allow for political signs, and they're allowed 30 days before one-stop early voting until 10 days after election. There are some limitations on that. There's no signs allowed on controlled access highways, so on the interstates. Those signs have to be at least 3 feet from the edge of the pavement, 42-inch height limit, 864-inch size limit, area limit, and requirements that those signs don't obscure visibility at intersections, don't obscure or replace another sign. And there's a requirement that the person placing the sign has permission from the adjacent property, private property owner. Now, an important note there, you can see my asterisk here beside political signs. The way this is defined for political signs, that is specifically content-based, and the state rules likely need to be updated in light of the Reed decision, but that's the way the state law is written now. It is specific for political signs as a category, and that plainly is a content-based category under the Reed decision. Separate from the NCDOT rights-of-way, there's allowance for municipalities to regulate signs in their rights-of-way. Cities have broad authority over their own streets, and then there's also the NCDOT statutes reference the city's authority both under the general police powers as well as under the city streets powers. And the city can completely prohibit signs in the right of way and just say no for because of clutter, because of visual impacts, because of traffic safety. We're not allowing any signs within the right of way. But cities may also allow for signs and just limit, give limitations, things like size, location, and other time frame limitations. If there's no local rules, then those state rules for NCDOT, those apply on the local streets. And if you're in a city, there's still state highways that run through that city. The rules, the NCDOT rules still apply on those streets that NCDOT maintains. Now, for some cities, the city itself maintains the NCDOT streets. And for those, then the local municipal rules would still apply. All right, I'm just about to run out of time, so let me make a quick mention and highlight on plan consistency statements. And perhaps if there's any lingering questions, if you'll pop those into the chat box, I'll see if I can get any of those last questions in my final minutes. As many of you know, there is a requirement for when there's a change to a zoning ordinance, when there's a zoning amendment, the city or county has to adopt a consistency statement to describe how the change, whether the change is consistent with the local plans and how it's in the public interest. Under the statutes, this statement should not be subject to judicial review, but there have been several instances where the consistency statement process has been challenged and has wound up in court. There's a recent change in 2017 this was, so not this past session, but the session before, giving some more clarification and identifying the types of statements that the governing board should adopt, depending on whether that amendment's being approved and consistent, or the amendment's being rejected and inconsistent, or if in the situations where perhaps the governing board is approving the amendment, but recognizing that it actually is inconsistent with the plan, in those cases, then there's a requirement that that acts as an amendment of the plan to bring it into compliance. Based off of a survey that we did at the start of this year, my colleague David Owens has just put out a bulletin on plan consistency statements, going through the law and the practice of how these are actually used locally. And my last slide, I've got a link to that. I've got a link to the website where you can access that report. Some of the interesting things to note with regard to the survey responses, the question of who prepares the consistency statement. 77% of those jurisdictions responding said that either the planning or zoning staff was preparing the consistency statement. How often does the board revise the statement? So once it goes to the planning board, once it goes to the governing board, how often is this getting changed? And essentially never. 88% of responding jurisdictions said that never or rarely is the plan consistency statement getting changed. Typically, the board is adopting the statement that was drafted by staff. A couple of other notes with regard to how these are being used and are they effective. A question of, is the board more familiar with the plan because of the consistency statement? Kind of mixed review here with 68% of the responding jurisdictions saying that there's no noticeable impact on the board's familiarity with the plan because of the plan consistency statement. And then a separate question, are zoning decisions more consistent with the plan because there's this procedural requirement for a statement? And 65% of the responding jurisdictions saying they saw no noticeable impact there. So questionable as to how much is this really driving the good intentions of the consistency statements to kind of help enforce the plan, help enforce make the plan a living document and inform zoning decisions. Perhaps it is, but the extent to which it's really driving a familiarity or driving local land use decisions, kind of mixed responses. One final thing I'll note there, an especially useful tool that's provided, or useful resource provided in the report from David Owens, is in the appendix. He has included sample consistency statements from different jurisdictions that might be useful for your jurisdiction in considering this. All right, with that, I'm recognizing that my time has run short, and that I'm sure many of you have 2 o'clock appointments that you will be dashing off to shortly. So this is the, hopefully you can access that link directly from your website from viewing this webinar. If not, you can jot it down and connect later. But this will take you to the planning and zoning website that David Owens and I contribute to, and it has a list of our publications and links to our courses and such. And then this link will carry you to the Coates Cannons blog, where you can find those various blogs that are referenced as we were going through. With that, Hannah, I'll hand it over to you for any concluding remarks or housekeeping. Thanks everybody for listening in and participating.
Thanks, Adam. Thanks everyone for participating in the webinar today. What a great resource to all of us in our day-to-day practice. If you have additional questions, please type them into the chat box now. Otherwise, a recording of this will be made available for a period of time for those who couldn't join us today. Be on the lookout for an email about that. Again, thank you all for coming, and unless I see some writing in the chat box here real quick, I think we'll wrap it up. All right, let's call this a wrap. Thank you all so much. Adam, thank you.
Glad to do it.
Thank you all for coming today.